many legal challenges, many extraordinarily complex issues, but particularly new issues for the definition of property rights and liability rules. And having the courts be in a position to sort through those is something that we look forward to hearing from Judge Williams and others. So please join me in welcoming Judge Stephen Williams.
I actually didn't realize that I was speaking under the auspices of the Center for the Study of the Internet. So there's been certainly no deliberate effort to tailor my talk to that, although there will be some overlap. My basic theme is that interest groups are essential to the creation of liberal democracy, but that they also have the potential to bring about its destruction. I should say that the title, besides my not knowing about the center, the title is the result of a failure of communications. Courts will play a role in my talk, but not the primary role that the title might suggest. I want to start with a few basic propositions. One, about divisions, a division in the way in which people get goods, services, perhaps even intangibles such as honor and esteem. One is through working and trading their work, or trading the products of their work. The other is through force or fraud, or the threat of force or fraud. Following the traditional Hobbesian model, we introduced the state to bring the Hobbesian nightmare under control and eliminate, or at least sharply reduce, the role of violence in settling problems. And I must say that if you look at the numbers for the death of particularly young males in primitive societies, it seems as if the Hobbesian bargain was a pretty good one. The death rates there, from what I've read, seem to be absolutely extraordinary, even by comparison with the many wartime deaths of the 20th century. Government, we have government with its monopoly on the legitimate use of courts. And I think it's important to bear in mind that really everything that government does involves either the exercise of force, which is fairly rare, or the threat of force. In many cases, it's easy to see that. In some, it's less obvious. Benefit programs depend on the threat of force because they are funded by tax revenue, which of course is collected under the threat of force. Even something as simple and benign as the allocation of the spectrum rests upon the threat of force, because it's only with the threat of force that the state could have acquired the power to exercise that allocative function. So that the things become, once you move out of sort of pure violence into violence and the threat of force, becomes impossible, I think, to really, what are the values involved, possible to measure to what extent there was progress. But in any event, we move into the world of the state, where we obviously are. I want to introduce at this point some labeling used by Douglas North, John Wallace, and Barry Weingast in their, in my opinion, wonderful book, Violence and Social Order. It's a great title to begin with. But it has a subtitle, something like All of Human History. That's not exactly it, but roughly it. Anyway, in their nomenclature, this initial state that we have, they call the natural state, and I guess it's fair to say its characteristics are, first, that it doesn't have any sophisticated divisions into judicial, legislative, executive that we associate with the modern state. And in the natural state, the distribution of rents takes, in their view, the form of essentially payoffs by the ruling elite or monarch to potentially rebellious factions to buy them off and prevent violence. One of the examples I love is a former teacher of property law. They look at wardship, which lawyers among you may remember. It's a feudal incident that went up to the overlord on the death of a vassal without an heir, and the overlord got the wardship, meaning the control of the property for the period of the heir's minority. Apparently the king didn't just sit around with that. What he did was to sell it off at a substantial discount to barons, and at least Northwallis and Weingast argue that they picked the barons who were to be the beneficiaries of this on the basis of trying to target potential rebels and essentially pacify them, and thereby advance the king's role as essentially a keeper of the peace within the state. When you think about that model, it seems to be one thing that comes to my mind is Afghanistan, and I think things that look to us like simple corruption and are on a daily basis called corruption may in fact, in part, or some of them in whole, be payments following this model of the behavior of the national state. I want to draw a contrast between payoffs like that and rent-seeking in liberal democracy. And the basic theme of this is the relationship between such payoffs like that and rent-seeking in a liberal democracy. When we see that in a liberal democracy, an economist would analyze it, I think, in terms of an agent's shirking, that an agent, either the executive or the legislative branch, as agent for the public, is shirking its duty by providing special benefits, not for the purpose of advancing the general welfare, but for the purpose of pleasing some constituents. I'll come back to that many, many times. I want to address the question of how a society moves from the natural state to liberal democracy, or what Northwallis and Weingast call the open access society. Of course, there are a lot of theories about such thing, and I wanted to deal with three, which are unified by the proposition that in all of these models, the change comes about through initiative from below. The people organizing to put pressure on the highest of the hierarchy to cease predation or reduce predation, to limit state predation. So the first of the three is Douglas North's description of England, and particularly the barons at Runnymede, gaining from the king promises not to increase taxes without the approval of the barons, essentially, and the Glorious Revolution, which is essentially a continuation of the same thing, except that in that case the king is removed and a new king comes in under a comparable bargain. Second, this probably is the most surprising to you of models, is Marx talking about peasants, and his argument is that when a peasant moves from classic peasant life as someone producing simply for his own consumption or to hand over resources to his lord, when he becomes a farmer and is producing for the market, he starts to engage in relationships with a much broader element of society, such that he gets himself into a position where, through alliances with other people, he can protect himself from state predation. And the third, I think this is the one you're least likely to have heard of, is John Powelson's analysis. And he has a whole collection of stories of producer groups, producer widely defined, peasants, artisans, particular types of artisans, merchants, particular types of merchants, so forth, joining an alliance, first on a narrow basis and then more broadly, again, to exert pressure against the central state and to minimize state predation. I may say all these accounts are highly anecdotal. This is a world where there are no multiple regression analyses. So some general thoughts on this issue of pressure from below. One argument is that reform without pressure from below just doesn't really count. It isn't real reform. I think that's quite wrong. And an example that tops to mind is Alexander II's emancipation of the serfs. Current historiography indicates that the serfs were not in a particularly rebellious mood at the time. This was not a change conducted under threat, but really reflected other things, probably to a significant extent the seeping in of Western ideas. And yet it was a transformative reform. Now, those who want to be cynical about it can say that the history of lord and peasant thereafter suggests that it was an imperfect reform, but of course, how many reforms aren't imperfect? So one, as I say, it's not perfect, but it's a very substantial reform that really counts. Another question about this pressure from below is need to be pressure from producers. In the Powelson model, it's always producers who drive it. But certainly, I mean, that would, I think, go a long way to eliminate the Douglass North story. And yet it seems that the barons at Runnymede and the elite who engineered the Glorious Revolution are probably not producers in any sense that we would fully recognize. Nonetheless, sought benefits that were highly advantageous to producers, such as protection from undue taxation and protection of property rights. So it seems to me that it's nice if they're to be producers, but it's not absolutely essential. And a final question, how broad need the coalition be? It seems to me the answer to that is the broader the better. And here I follow Mansur Olson when he talks about encompassing interests which essentially the breadth of the coalition is some sort of a guarantee against the coalition using its power just to gain special benefits for itself, and rather seeking things that are of broad benefit, again, such as the protection of property rights and establishment of the rule of law. Often it's said by people sort of looking at this history that the great step forward is protection of investment. And that's true, but not true. True in the sense that, yes, it's important, but it's certainly not sufficient. And I would direct you to the Soviet Union. We had loads and loads of investment. It's just that it's guided not by an effort to satisfy consumers, to produce things that consumers would willingly buy, but to satisfy agendas of leadership in the narrowest sense, of course, Stalin. Now I want to talk about a couple of changes over time that, again, Northwald and Weingast talk about. And I think they're right to stress them, but I think they may slightly overread them. And the first is the shift of incorporation, process of incorporation, from being a special deal where a group of incorporators goes to the legislature, gets their incorporation charter blessed, characteristically with a monopoly of some sort. And what we see today, what we have seen in Britain, France, and the United States since the first half of the 19th century, anyone who wants to start a corporation goes into an office and files a few papers. And they, Northwald and Weingast, argue that in the earlier period, before general incorporation, the corporation was seen as a device, one of the favorite devices, perhaps the favorite device, for channeling wealth to private interests who had a connection with politicians. And the classic instance there is the South Sea Corporation, indeed, had special privileges enabling the incorporators to virtually mint money. In our history, the example that is seen somewhat the same way and may not be is the Bank of the United States, Jackson's attack on it, certainly in language asserting that it was simply a device for privileging a certain group of people, enabling them to make money through a privileged position. I may say that the battle about government banks was fought out in a lot of states that era, again, very much using Jackson's rhetoric. And this, the hostility to the corporation as used as such channel of privilege was widespread among the Whig political theorists, our framers, and of course, instead, the Jacksonian Democrats. So after, with general incorporation, the device is available to support, to sustain competition in the market. So I should add that they point out this is paralleled by an opening up political competition through the broadening of the franchise. So the change turns the corporation inside out. Instead of being a device for political privilege, it becomes a device for market competition. But although facilitating competition, it obviously does not eliminate the risk of rent-seeking activity. There's a great battle about this between the majority and dissenting opinions in Citizens United, which I refer you to if you're interested in seeing how it's playing out nowadays. The other change that North Wallace and Weingast stress is a change from personalism to what they call perpetually lived institutions. And they have all kinds of curious history, which I won't go into with you, but I mean, it turns out, for example, that state treasurers at the beginning of the 19th century owned the tax money that they collect from you as taxpayer, and until they turn it over to the state, they are the owners of that property, so that if they gamble with it or something, that loss is, well, of course, if they gamble with state money, that loss would be inflicted on the state too, but at least when they're seen as agents of the state, it's easier to concoct devices which frame their activities as being on behalf of the state, collecting money on hope for public purposes. Now, although they don't say this in so many words, North Wallace and Weingast appear to at least hint that the shift away from personalism militates against rent seeking, and I'm somewhat doubtful. And I would try to compare the payoff in the natural state with, in a liberal democracy, rent seeking, which is not personal at all, but to a whole class of persons described generally in legislation and taking the form of preferences in government contracts, subsidies, and also, of course, rules obstructing competition on behalf of some favored group. And all of you can think of many examples of those, of all those systems today. Now, looking at these two phenomena, the payoff in the natural state and the kind of broad scale rent-seeking activity, they both stand in complete contrast to the idea of free competition to satisfy consumers on the basis of their willingness to pay. And they both involve insiders' use of pull. So they have that moral characteristic. They have this difference. The rent-seeking in a modern liberal democracy is not needed to preserve peace. So besides being broader than the payoff in the natural state, it lacks the contextual justification that the payoffs do there. So the result is that as more and more of the economy is molded by rent-seeking behavior, liberal democracy is hollowed out and returns toward the natural state again. So the progress of 800 years is frittered away. So what is there to impede the growth of rent-seeking in a liberal democracy? Give you very briefly Gary Becker's, I think, way over-optimistic view, which is that the competing interest groups, and including the taxpayers who are going to fund one set of rent-seeking activity, and consumers who are going to fund the other set, this competition, they all have an interest in doing this, that is to say, transferring rents to the beneficiaries at the lowest possible cost. And so he seems to end his article on a sort of rosy note. But I have two problems with this. First, on all his assumptions, he doesn't come to grips with what the actual cost will be under this least wasteful form of rent seeking. And both the normal costs of it in terms of the misallocation of resources, including the resources devoted to rent seeking, which would otherwise be devoted to productive activity. The other thing that he overlooks, and this I'll come back to several times, is the need for a cover story. When rent seekers want a benefit, they don't just say, give us a benefit. They say this benefit will produce all kinds of wonderful public things. So the owners of land suitable for growing corn do not say, yeah, just give us $50 billion. They say, give us subsidies, regulations, all kinds of things to enhance the sales of ethanol, to make ethanol a product, a marketable product where otherwise it might not be. And the economy will be better, we'll have energy independence, we'll be greener, we'll fight global warming, everything. And once you introduce the need for a cover story, you introduce a lot of other things. I mean, in this case, most obviously, a whole industry of let's face it, dubious value, and also the effect of special rules like the tariffs on Brazilian ethanol, which are necessary, would not be necessary in a simple deal of cutting checks to corn growers. So I think Becker is hopelessly optimistic. I do want to say one thing about his scheme, and that is that it is an invisible hand solution, by which I mean it is not a solution that requires some intelligent entity, some intelligent person to enact or reform. It is something which simply operates through people responding to various existing incentives. And I think we ought at least to look for solutions belonging to that class to see if they give us any hope. Anyway, let me summarize where I think we've gotten to. First, the proposition that interest groups are two-sided. They're essential to the creation of liberal democracy, but they have a likelihood of undermining the whole transformation. With liberal democracy, these payoffs are much broader than those of the natural state, but lack its justifications. The various progressions that have occurred in Western economies, corporations, perpetually lived institutions that help but don't get us a full solution. And finally, we have the promising, but I think in the end inadequate analysis by Becker. So, remedies. I'm going to talk about two types of remedies. One is judicial, which I guess this will be the part of the talk that fits the first word of the title. And the other is back to invisible hand remedies. For judicial remedies, I want to talk about some possible modes of statutory interpretation and also a constitutional doctrine. In the statutory interpretation range, I want to talk first about interpretations that encourage competition at the edge of natural monopoly regulation, and also of an interpretive presumption Congress would not intend an agency to deliberately benefit a particular industry. And both relate to the hope of enhancing openness in the economy and repelling rent seeking. First place, encouraging competition at the edge of natural monopolies. Congress often notes something that appears to be a natural monopoly and adopts a regulatory scheme and vests an agency, such as the FCC, with the authority to go out and regulate. But it often turns out, perhaps it uniformly turns out, that there are, at least at the periphery of this industry, perhaps more broadly, but certainly at the periphery, there are economic activities which can perfectly well be competitive, but the regulatory agency may not see those opportunities. And there are a couple of, I'm sure there are more, but at least there are two instances that I'm familiar with in which my court, my predecessors on that court, pushed the FCC in the direction of allowing competition where it's perfectly feasible. The two great areas are Hushaphone and Execunet. So if people have questions about that, I'd love to discuss them. And incidentally, in this area, the presence of a regulated monopoly means that you have a state authority in a, what you might call a playpen with rents to play with. And the larger the monopoly they're playing with, the more fun they can have. To the extent that you cordon off some of that area for competition, you reduce the size of the playpen and the opportunities for this sort of activity. The other, an interpretive canon against supporting a particular industry, the example that I have in mind, and it actually stems from a particular case, Congress directs the EPA to develop standards for some pollutant. And the EPA does so, and in explaining why it arrived at a particular standard it chose, it says, and this will help the such and such industry. Now, there's no mention of the statute of helping the such and such industry. And in that case, it was pretty easy. I mean, we essentially said the clear language statute bars the agency from relying on this. I think one might go farther, suggest that possibly it should be a sort of general presumption that unless Congress is pretty clear about it, it does not want agencies to go out and use their power to support a particular industry. Both these thoughts are in the spirit, I think, of the Whig political philosophy and the framers' views. Now, the rule against partial legislation, that is more commonly known as substantive due process. I like the rule against partial legislation better because partial means biased in favor of particular economic interests. And so that targets what the real concern is. And I want to just read you a sentence by the leading scholar of these cases, which were brought to an end with the switch in time, say, of 9 in the Roosevelt presidency. Howard Gilman concludes, most of these cases demonstrated a superior judicial commitment to the familiar Jacksonian preoccupation with political equality or government neutrality. The belief that government power could not be used by particular groups to gain special privileges or to impose special burdens on competing groups. Sounds certainly again like the Whigs and the framers. Now, Gilman himself believed that the doctrine properly died because he thought modern life had become too complicated and certain groups were at undue risk of being unfairly treated by the economy in the absence of the kind of legislation which bit the dust under the rule against partial legislation. To me, the more serious objection is back to the cover story, and that is the problem of courts in trying to sort out what legislation really simply aimed at advancing some rent seekers' welfare and what legislation pursues legitimate aims. And here I'll invoke Bruce Gandel's analysis of prohibition, which he explains is product of an informal alliance between Baptists and bootleggers. The Baptists want to save us from drunkenness by preventing the sale of booze. The bootleggers want to increase their profits by banning the legal sale of booze, meaning that only their particular field, the illegal sale of booze, will be able to go ahead. I can see in all of these cases that about half of the modern judiciary would see the Baptist argument and say, that's it, that's what's controlling. And another half would see the bootlegger's hand at work and be ready to strike it down. And I think with such a degree of division, it would lead to the doctrine being seen as illegitimate. Now, there is a field where actually the courts do engage in just this process, and that is the negative commerce clause, where in one branch of the jurisprudence, they conduct a so-called balancing test. This is a test of state legislation to see whether it's legitimate under the Commerce Clause. It's not an undue burden on interstate commerce. And the first step of that is to identify first whether it really is a burden on interstate commerce. Suppose it finds it's a burden, then it goes on to look at the stated legitimate purposes of the state rule. And essentially, if it finds that the fit between the actual statute and the stated purposes is not good enough, then the balance tilts against the statute and it's invalid. So this could go on. I mean, this is closely parallel to at least a way the rule against partial legislation could function. Why not? Why shouldn't the doctrine be revived? Well, the first thing that occurs to me is that the scope of the legislation subject to this review would be vastly broader. With the negative commerce clause, it's not a small set, but it's certainly not a huge set of laws which are subject to this kind of review, which create enough of a burden on interstate commerce to elicit the court's interest. So it's somewhat narrow. They're all state laws, incidentally, too. And as a result, there would be this dispersion of judicial reactions that I talked about before. There's the recent discussion of Lochner, which David Bernstein's book, Revive, raises some questions. If people want to ask about them, I'd love to talk about that later. And then there's an extreme form of this review, which comes under the name purpose peeling. It's actually came devised by a friend of mine analyzing a Supreme Court case. And the practice is this. You look at the statute, and the state proposes three purposes. And the court looks at purpose one and the statute, and it says, it doesn't quite fit. It's overbroad or insufficient for purpose one. Then it looks at purpose two. Same story. Not a perfect fit between the purpose and the statute. Same for purpose three. So it obviously wasn't aimed at accomplishing those purposes. It's did. Now, all those justices know perfectly well that legislation is the result of compromise. So they know there are perfectly legitimate reasons why a statute would not perfectly match up with any of its three justifying purposes. So it may be a perfectly reasonable compromise between all three. If you have that kind of thing, I think you can expect the document perceived as illegitimate. I still would say that in a world where rent seeking is now recognized as a serious problem for all liberal democracies, but certainly including ours, it may be time to at least try to rethink that doctrine, see if it does have some place in our jurisprudence. Now I want to turn to invisible hand solutions very quickly. First, internal ones, Gary Becker's example is one. There's another form of invisible hand solution, and that is the kind of political competition that produced the Tax Reform Act of 1986. There, essentially, you have people perceiving that the tax code is filled with special deals. If we eliminate some of those special deals, we can reduce rates and make most people better off, and that's what happens in 1986. The difficulty with this, and this is a political competition model. I mean, you have political entrepreneurs who see the chance to make a gain by carrying out this transformation. Now, the difficulty with it is that, apart from the fact that it doesn't seem to happen that often, within the next year, they were loading up the code with similar special deals. And so it's somewhat discouraging. Now let me turn finally to international competition, and I see three forms. One is military, the other is imitation, and the other is the magnet. Military, very quickly, I think it's true. A society in which rent-seeking is minimized, will, everything else being equal, likely to be a more powerful society than one where it is not. But, and indeed, we won the Cold War not without firing a shot, but firing comparatively few shots. Still, reliance on that as a device for Darwinian sorting out of the better societies from the worst is really costly. That seems obvious. I won't elaborate. Imitation. It does seem to me that you do have imitation. People point, for example, on the positive side to Social Security measures in Chile as a possible way to go for us. On the negative side, people point to the extraordinary, the rich proliferation of rent-seeking in Greece. I can give you some nice anecdotes about that if you'd like. And that, I think, is seen as a negative example, a way we do not want to go. At least have some force. Then in the magnet effect, and I think it's Hayek who's very much into this Darwinian struggle as a way of sorting out the better set of rules from the worst set of rules. I think that's probably what he mainly has in mind. And it does seem that hardworking, entrepreneurial, intelligent people are likely to be drawn to migrate to a society where rent-seeking is relatively low, and therefore opportunity is relatively great, and the same would be true of investment. That to operate, of course, a society to win in that form of competition has to see the connection between its rules and the possible benefits that it may get in the form of this migration of investment and people. Can the quality of public thinking about the relationship between the rent-seeking activity and benefits, for example, in the form of the magnet operation, can that understanding be improved? It seems to me that surely if the public had a rudimentary understanding of economics, we'd be better off. And that could happen if the press had a rudimentary understanding of economics. But I have vividly in my mind opening up the Washington Post and reading a story in which the reporter is just tickled to death by what he regards as the absurdity of, I don't know whether it was a staffer or a congressman or a professor testifying or what, but somebody invoking the concept of moral hazard. And the reporter thought this was just so highfalutin, so absurd, to imagine that invocation of concern for moral hazard could play any role in assessment of legislation, just totally beyond him. Now, until we get reporters who are able to grasp pretty basic concepts like that, I think we're clearly in a bad way. I want to leave you with something slightly more cheerful. I want to quote the last president who seem to grasp the problem. It is said that in advice to his successor, Calvin Coolidge said, "You have to stand every day 3 or 4 hours of visitors. 9/10 of them want something they ought not to have. If you keep dead still, they will run down in 3 or 4 minutes. If you even cough or smile, they will start up all over again." Thank you.
Judge, that was a wonderful talk. We've all learned a great deal. Going to have some questions and answers. I will take the moderator's privilege of asking the first question, which has to do with the role of technological change and how different government institutions deal with issues related to rent-seeking in a modern society. And let me be more specific. You gave the example of how the courts address, was it issue peeling and negative Commerce Clause evaluation and the like. And it struck me when you were describing the issue peeling that a lot of times government agencies, and you know which one I'm mostly thinking about, address issues that are based on a technology that did not exist at the time that the law was written. And you can see this in the Hush-a-phone decision to some extent, although it's the agency taking extraordinary liberties with the statutory language. But we live in a world in which statutes change far less rapidly than technology does, and this has effects today in issues related to privacy, to law enforcement, intellectual property, contracts, taxes, and how does a court deal with that? For example, in the area of issue peeling, to say, well, these laws will only be written once every 40 or 50 years, and technology has many cycles during that. And how do we evaluate the application of laws by agencies under those circumstances?
Yeah, well, I mean, let me focus on that in the context of actually the FCC and in those particular cases, Hush-a-phone or the Techinet. I went back to those cases in preparation for this, and the interesting thing is that the reasoning provided by the court is, I won't say non-existent, but as Hush-a-phone. Hush-a-phone is, for those of you who don't know about it, it's a wonderful story. It actually starts a huge and important chain, but somebody, the Hush-a-phone company, comes up with the idea of something that someone using a telephone puts on the receiver, and it makes it easier for him to hear what's coming out, and also to speak without being heard by people in the neighborhood, without having his interlocutor heard in the neighborhood. It's a piece of foam rubber or something, and AT&T objected to this, said it must be forbidden, its sale must be forbidden, because its use would degrade, would impair the use of AT&T's facility. And the court had an easy time with that. It really just laughed. It said, this is silly. And that seemed right. So that was pretty easy. Execunet is a more sophisticated problem. I won't go into it. But in the case where in practice, the court's order enormously expands the realm in which competition is allowed to operate. Proposed competition has now clearly, maybe it was before, but it's now clearly become technologically feasible. And the court pushes ahead, and that comes about long distance competition, long distance service. But the interesting thing is the court relies entirely on rather formalistic ad law doctrines and never says, and we're doing this because the opportunity for competition having opened, you guys ought to do it. So I was trying to think, could the court have said that? I mean, certainly the court could have said, the opportunity for competition is open, and the statute is loose enough so that you could take advantage of that. I don't know if the court could, our view of the proper role of court, could say, and you must.
Right.
Now, what it could do, of course, and courts have done this a lot, is to say, well, you didn't take this into account, so you reconsider it. And then the SEC could reconsider it, and sort of like grading exams, the court could say, well, you considered it, but you overlooked factor A, B, and C, and you did a lousy job, so do it again. And maybe the court can do that enough so that a result happens. It's, a lot of people would frown on that. Some people have thought some of my decisions fitted into that category, but in any event, it's hard to see a court going farther than that. But in that context, we're talking about a very broad word statute, so that up to the age, a lot of leeway. But I think the only clear avenue open to the court is to say you have to explain this relationship to the current technique, which potentially are.
Let me open it up the floor for questions. Michael in the back. Nice.
First, can I ask the panelists to speak more closely to the microphone when they do? Can I suggest that at least one approach might be to force greater transparency in one-track decision-making? To take the example that you've given, why not find ways simply to use the appropriations process as the singular means of distributing resources? It cuts back, of course, on the cover story phenomenon that you talked about. It allows the competition for resources, as I say, to be on a single appropriations track. So that instead of saying, and again, to get your example, let's have 10% of X in our fuels, let's write out $50 million checks or $100 million or $6 billion checks to corn farmers. Why don't we just go down that route to a greater degree, perhaps judicially, but also, probably least of all that way? It will limit the regulatory. It has the further virtue of limiting the regulatory state and in a pro-democracy kind of way, forcing legislative decision-making over that. But why don't we move in that direction of just shunting and moving these resource allocation decisions to the appropriations process to the extent possible? Is that a possible way to go?
Well, it seems to me that under our current Constitution, it's impossible because there are clauses of the Constitution giving Congress all kinds of powers beyond the taxing and appropriation power. Yeah, I guess, occasionally Congress does something right. We don't want to adopt a set of overarching rules that completely prevent that from happening. Now, what are some examples? Well, I know this is contestable, but at least certain branches of the antitrust laws seem to me a good thing. So there's something in the regulatory zone. Something as modest as allowing interstate use of subpoenas for the purposes of fraud litigation to reach out-of-state perpetrators and witnesses seems to be something that Congress can do that's not in the appropriation realm, but is useful. I don't think Congress has done much of that, but anyway. So I mean, I think would probably sacrifice too much. I should briefly tell you Hayek's solution to this. Hayek took the view that indeed there were laws that a legislative body might usefully enact, but he saw all the risks with allowing them to do it. So he proposed a kind of super legislature, which would be elected. I think it's 15-year terms, and each third gets elected every 5 years. You can only serve one 15-year term. You're only eligible at the age of 45, and some kind of honorable retirement is provided for you at the end of it, so you don't have much incentive to fight on or to try to, obtain glory. And this would have a power to veto the activities of the ordinary legislature. Now, I mean, I think that's, I think it's a wonderful creative thought, probably not realizable, obviously not realizable here without a constitutional amendment. But it is less draconian than the solution you offer, and that seems to me a plus for it.
It seems to me that a lot of this special interest capture happens in the trenches of the agencies. And I would suggest that one of the disasters turned out to be the Chevron doctrine. That it took you guys out of the business of at least enforcing the compromises and making sure that the bargains were kept, and simply gave the agencies too much power to determine their own jurisdiction and their own ability to rent seek. Agree or disagree?
I certainly understand what you're saying, and such thoughts have gone through my mind more than once. But one thing that's very useful to bear in mind in thinking about eliminating the Chevron doctrine is a doctrine of considerable judicial deference to agency interpretations of the statute that they are charged with implementing. One great plus of it is that it reduced the incidence of judges going off on a toot of their own. And in the bad world before I became a judge, there were a lot of cases of that. Just take the Prevention of Significant Deterioration rules under the Clean Air Act. There was not a clue in the Clean Air Act that there was the EPA had such a mission, anything remotely like that. A panel of my court concocted that out of whole cloth, out of actually, I think, a couple of words in the preamble to the Clean Air Act. And now, in fairness to them, in a sense, they got what the Congress of that era apparently thought was right, because then Congress came back and enacted a vast statute implementing this new DC Circuit program. But still, it shows the kind of thing that went on in the pre-deference era. And I don't know. Let me put it this way. I'm not uncomfortable with Chevron. It's a good thing. I've been living with it for 25 years. So,
Judge, if I could just follow up on that. I can think of several decisions, actually not from the D.C. Circuit, but there seems to be, I'll call it selective application of Chevron deference, where judges on other circuits will, I forgot your phrase, but they'll do something that's.
Well, it's not. I don't think this is purpose peeling, but I understand what you're talking about.
but then when they're confronted with a set of awkward facts like the absence of a record, and the agency goes on ahead and does something that's Chevron deference. So it seems to be. I wonder how much it has really inhibited some judges, not on the D.C. Circuit, but some judges from engaging in fanciful.
Well, a study was done of Supreme Court decisions after Chevron, posing the question, among other things, how often do they, who invented it, apply it in contexts where under its terms, it's clearly applicable? And the answer is sort of randomly. Sometimes they mention it. Sometimes they mention it and sometimes they don't mention it at all. Sometimes they mention it but don't pay much attention to it. Sometimes they mention it and grovel before the agency or purport to grovel. So, I mean, you're certainly right. I mean, I like to think we're more dutiful about it, but I think you're surely right that it's applied with a twist.
Judge Williams, I was interested in your comments about the negative commerce clause interpretations by the judiciary. I don't know whether you had occasion to look at the 11th Circuit decision in the healthcare reform mandate case, but it seems to me that they were applying rather similar techniques of purpose peeling and balancing to determine the bounds of the federal Commerce Clause powers. I'm wondering whether you see that as a growing intellectual tendency.
I'm not sure what that is. That seems a tricky word in that question. Growing, I mean, I think it's pervasive. Probably it's been pervasive since there have been judges applying the Constitution to statutes. I mean, I think it's some sort of, I mean, this is what I was troubled about in resurrection of the rule against partial legislation, a difficulty of applying it in a truly even-handed way and thereby illegitimating the application of the doctrine. And I certainly can't speak to the 11th Circuit's decision on that question. It's actually going to be may have been argued the last day or so in my court. I guess we'd read of it in the press if it had been argued. Anyway, so it's very much alive, but there is clearly a risk of that. But one thing I've noticed about the two, well, not putting aside the Fourth Circuit decision, the two circuit court decisions until we got to the Fourth Circuit, the ones that addressed the merits, I was interested that in each case there was a sort of anomalous vote in the sense of, on the Sixth Circuit, a Republican appointee who voted in favor of voted to uphold the constitutionality of the statute, and on the 11th Circuit, a Democratic appointee who voted to invalidate it. So, in a sense, that suggests that possibly neutral principles can be found. Of course, they must be different neutral principles because the outcomes were different in the two cases.
You'd mentioned in the beginning about producers being part of the picture, and I'm wondering, with technological change over the years and more being produced, if more emphasis is given to producers.
Oh. More emphasis by whom? Well, I mean, I was talking about them sort of in the evolution to liberal democracy, and certainly, I mean, to the extent that they play a role in generating the rule of law, protection of private property, enforcement of contract, that seems to me a great thing. Once it's established, does their role change? I mean, I don't really know. I mean, I guess you could ask the question, well, I mean, producers are after different things, right? You know, the rent seeking is not limited to the groups that people in this room would regard as bad guys. It includes lots of seemingly fine, upstanding businessmen. So most of these rent-seeking issues involve fights between, I mean, a lot of them involve fights between producers. And so one thing that I do think is important, and that is in terms of reducing rent seeking. When a special benefit is in place, how often do you see it cured by being removed? Or how often do you see counterbalance being achieved by its removal? Almost never. What you see is some new counter rent seeking activity coming into effect. So, I mean, this isn't quite the same, but look at Brazilian cotton, although I believe there's been legislation which corrects the matter. But our special deal for cotton leads to an adverse decision in the WTO. Ah, terrible problem. What's the solution? The solution is United States subsidies to Brazilian cotton growers to buy them off. This surely is carrying the whole thing to lunatic extremes, but I think you see that everywhere. The answer to one set of suppliers' privileges is a set of privileges for another set of suppliers, and it gets worse and worse.
In the back.
Judge Williams, on there are two examples this week, actually, that came to my mind earlier in the week and reinforced by what you were talking about in terms of rent seeking. The story involving Solyndra, a company that is, by all intents and purposes, something that the administration wants to do and seems to, they love to, not too wisely, but too well in terms of helping them. And in the communications area, as Harold's probably following, the issue with Light Squared, where, again, an idea that almost everybody agrees we need more spectrum. Light Squared has an innovative approach, but some say kind of jumped ahead of the line. So these are rent seekers, obviously, trying to get a benefit from the government, and as you say, they're both good and bad rent seekers, and at least in terms of public policy, these seems to be two that first blush seem sympathetic. They also were engaged somehow in ways in the political process. If somebody came to me as a lawyer and said, how do I get something done in Washington, I wouldn't just say, write a really good white paper. There's lots of important people you have to meet and see and talk to, which is what these companies apparently did. The question I have is, they're sort of doing what our system says to do, and yet they both now find themselves at the end of the week in some state of embarrassment. Your thoughts?
Well, I mean, one of my reactions to that is that all the actors start in a system which, in a sense, is hopelessly corrupt. So you're right. What can they do? I would draw this distinction, and I know that it's a distinction that breaks down, and that's offensive and defensive lobbying, if you will. It seems to me it clearly counts as offensive where you're asking flat out for a special privilege for yourself or your group, and it counts as defensive when you're resisting the pursuit by a competing group of some special privilege. Now, I know that there are all kinds of intermediate cases, and for example, Light Squared, I wouldn't even dream of beginning to sort out where that fits. And that in a sense takes us back to the problem of the cover story. Some cover stories are actually good. And it's that seems to me, I go a little further on this business of offensive and defensive. The fact that the press is economically illiterate means that lobbying is treated as a sort of undifferentiatable lump, and it's all lobbying is wicked in the views of the press. There may be some special privileged lobbying that they'll acknowledge, but for the most part it's viewed as just bad. but in a world where there are a lot of rent seekers out there, for people to use lobbyists to protect themselves from the rent seekers seems to me a darn good thing. But I do not think it is easy always to tell the difference between the offensive and the defensive use. But I do think that the press leaves the American people totally at sea in any efforts they might make to draw that distinction.
Up here on the left.
Thanks. Judge, thank you for your remarks. Very interesting. If I might return to the book that you started out
Yes.
with, one of the most striking things I found in that book was fundamentally that North Wallis and Weingas took issue with Mansur Olson on the concept of over time more interests become organized and rent seeking increases and the drag on economic growth becomes worse. No, they argue,
Right.
more prolific organization in society, I think they think through greater countervailing power, actually restrains rent seeking
Yes, yes.
and leads to a solution or at least an amelioration of
Yes.
the problem.
Yes.
I wondered if you had any views on that controversy about the implications for the severity of the costs of rent seeking
No.
associated with greater organization of interests through time.
Yeah. I have to say that I certainly saw the same conflict going on, and it seemed to me that to the extent that they sought to refute Olson, they did not succeed. Their analysis about competition is not exactly the same. The way competition could cut rent seeking down is not identical to Becker's, but it's quite like it. It's more like the 1986 Tax Reform Act, which I think, in fact, they cite as an example. But for the reasons that I gave, it seems to me that, the history just doesn't bear them out very strongly on that. And that's somebody, I think it may be one of Jonathan Rauch's books or a book he cites, I forget, pulls together data on the proliferation in Washington of the association of fill in the gap. And it's just a curve that skyrockets up, and I don't see that curve as cutting down the phenomenon at all. It seems to me it more commonly results in this countervailing rent seeking, which just makes matters worse. I thought that was the weakest part of the book. A wonderful, I repeat though, a wonderful book.
I see three more hands, and then we'll all quit. So, microphone. Yep.
Judge, your comments about defensive rent seeking started me thinking about where the demand for the demand, loosely understood, for the partial legislation originates. And sometimes it is the case that any Washington lawyer who can fog a mirror knows there's going to be legislation in an area. The Congress, for its own reasons, wants to look useful on banking. Congress, for its own reasons, wants to look useful on some other subject, or healthcare. There will be legislation. And in those circumstances, it seems to me you can either have lobbyists going in trying to plead their own particular partial causes, or you can have blind man's buff going on in the Hill. And there is an informational transmission that goes on in lobbying. Now, it's not unbiased, and it's not angelic, but I'd sure hate to have them writing legislation without hearing from the people they regulate. I wonder if you had any comment on that.
Oh, I absolutely agree when stated that way. Yes, that they should hear from the people who are going to be affected. I mean, the difficulty is that partly because a lot of them don't have rudimentary economics, they seem to have a hard time sorting out the good arguments from the bad arguments. And which incidentally, assuming a revival of the rule against partial legislation, would plague the court's application of the doctrine. So, yeah, you're quite right. They should hear, and in an ideal world, they would have some capacity to separate wheat from chaff, but we don't seem to live in that world. So, yes, and incidentally, I guess that, I mean, we've seen the application of the First Amendment in the campaign finance area. I don't think we've seen much of it applied to law. No case comes to mind of its application to lobbying, but just as a wild guess, I would say that at some point, lobbying rules could start to entrench upon First Amendment values and would be treated accordingly.
Here, might be another hand now, but go ahead.
Earlier you mentioned the theory of moral hazard and also the U.S. Constitution, but isn't one of the problems the fact that through sort of progressive administration and the rise of it through congressional law, removal of powers of the president over the executive branch, and case rulings by the court system has essentially changed that to the point that Congress doesn't actually legislate anymore. And by having Congress forced to accept the moral hazard for their laws that they themselves actually pass, rather than handing it off to the administrative branch outside of the control of the president, that with that we can have sort of a majority be accountable themselves for choosing their electors to protect them from rent seekers?
Yes, in a way. I mean, I want to answer cautiously. I am probably the last federal judge who wrote an opinion finding that a congressional law ran afoul of the non-delegation doctrine, and I was quickly reversed in a unanimous opinion by the United States Supreme Court. So I'm gun shy on that, but I think the arguments, there are serious political science arguments for the non-delegation argument, but they don't seem to get much of a hearing. I think it would probably represent a marginal improvement to have a vibrant non-delegation clause. I don't think it would solve the problem. It might push the frontier in the right direction.
Thank you, Judge, and as a lobbyist, I appreciate your comments, recognizing that some of us could have some value. But I want to return for a second to the Chevron doctrine, and I think your point, which I agree with, that the rent-seeking that goes on can undermine a democracy at the end of the day. When you sort of recognize that the more established, larger groups typically will be more effective at the agencies, when you get to the courts, the same in a way seems to apply through the Chevron doctrine, in that if I represent the little guy, it's very expensive to go to court.
Yeah.
And I also typically don't have the resources to withstand whatever I'm complaining about for very long. And so the question I really have is, when you look at the Chevron doctrine, while I can see its value to the courts, I think the biggest complaint I've seen from small groups is that when they are successful in getting Congress to adopt some protections for them through a law, that then the larger rent seekers are successful in getting the agency to undermine. The application of a Chevron doctrine that says we're not going to look at the statute, we're going to sort of give that a quick brush and then move on to deference, seems to punish those groups that may have in some small way succeeded in the Congress. And I'd like your thoughts on that.
Yeah, I think you somewhat overstate the Chevron doctrine. We do not just glance at the statute. We spend hours poring over the statute. And many people actually object that we aren't as deferential as the doctrine calls for us to be. I mean, I guess in the cases that have come to me, I can't at this moment anyway recall a sort of small guys, big guys conflict. I mean, I'm sure they're there. I mean, the painful fact, which you're probably very much aware of, is that most of the guys who find it financially worth their while to do the litigation are pretty big guys. And that's probably why we don't see much of a small guy, big guy conflict. But as I said, I don't think I hope I've not failed to see it just because I was neglectful. But I mean, you raise a good point and sensitized me to the small guy problem.
With that, I think that's the final word. Please join me in thanking Judge Williams.
Oh, well, it was a very good audience. Full of good questions. And hi, how are you?
It's true in the environmental field, the courts became a one-way racket.
Yeah,
And Chevron itself, of course, was the agency trying to do
That's
something
right.
reasonable.
That's right.
I wrote an essay at the time on a fine decision on the
Yes, but now, of course, there the agency was doing something smart.
Yes.
Which will happen.
Yes. And I thought,
We can't exclude that.